Under the Indian Contract Act of 1872, you can state an intention as clearly as you like. You can offer 1,000 rupees, and the other person can accept. But without something given in return, that naked promise holds exactly zero legal weight. The state will not enforce it. The rule is absolute. No consideration equals no contract. This diagram maps the architecture of a binding legal instrument. To transform a mere promise into a legally enforceable reality, it must survive 3 structural stress tests. It needs the fuel of consideration, the qualified operators of capacity, and the genuine volition of consent. Pass these tests, and the state grants you a valid contract. Fail them, and the agreement is either legally dead on arrival, what the courts call void, or it becomes vulnerable to cancellation, known as voidable. The law ignores the specific words spoken in an agreement to focus instead on the underlying structural integrity of the exchange. This vector represents consideration. It is the required engine of the contract. It demands that something be given in return, whether an act, a promise to deliver goods later, or choosing not to take a specific action. And it must occur exclusively at the desire of the promiser. The exchanged item must possess legal value, but the law ignores market equivalence. If you agree to trade an 8 lakh rupee house for exactly 2 rupees, the court considers that a valid exchange of consideration. This strict requirement creates a legal paradox regarding third parties. The general rule is clear. A stranger to a contract, someone outside the direct agreement, has no legal standing to sue. Look at this 3-node network. While a stranger to the contract cannot sue, a stranger to the consideration has legal standing to enforce the agreement. If person A transfers property to person B, and in exchange B promises to person C can legally enforce this deal. Consideration can originate from any person, including those who are not party to the benefits. There are strict statutory exceptions where this engine of consideration is entirely waived. The first is an agreement based on natural love and affection between close relations, provided it is written down and officially registered. The second exception is a written promise to pay a time-barred debt, an old obligation that has passed the legal statute of limitations. The final immediate exception is completed gifts. When the gift is handed over, the giver cannot legally revoke it by claiming a lack of consideration. Unless you meet one of those precise statutory exceptions, consideration is the mandatory fuel for legal enforceability. Attempting to bypass it destroys the contract's validity. Even with valid consideration, you hit the absolute barrier of capacity. To operate within a contract, an individual must be of majority age, of sound mind at the exact moment of signing, and not statutorily disqualified by conditions like insolvency. The rule of minority is aggressively protective. Under the precedent of Mohiri BB versus Darmotis Ghose, an agreement with a minor is void ab initio, void from the start. This protection is absolute. There is no rule of estoppel. A minor can lie about their age and still escape liability.
And there is no ratification. They cannot sign a contract at 17 and retroactively validate it the day they turn 18. The sole exception to this immunity is a contract for necessities. If you supply a minor with basic survival requirements like food, clothing, education, or emergency medical care, the law recognizes an obligation. However, the minor remains personally immune. A supplier cannot sue the minor directly. They can only legally attach a claim to the minor's physical property or to their estate to recover their costs. Legal capacity acts as an impenetrable firewall. Without qualified operators, the legal instrument never actually comes into existence, regardless of the money exchanged. The final pillar demands a core psychological requirement, consensus ad idem. Both parties must agree to the exact same thing in the exact same sense. When this consent is distorted, it creates voidable conditions. These distortions leave the contract standing, but grant the aggrieved party the power to cancel it. The first external pressure is coercion. If consent is extracted through a direct physical threat to life or property, including the threat of suicide, the agreement is voidable. The second is undue influence. This is the misuse of power within a strict hierarchical relationship, like a doctor and a patient, or a guru and a disciple, where one party leverages their position to gain an unfair advantage. Informational asymmetries operate differently. Fraud requires intentional deception. It involves stating false facts, actively hiding the truth, or making fake promises. Simple silence isn't fraud. unless the law imposes a highly specific duty to speak, making silence equivalent to a lie. Misrepresentation happens when a party makes a false statement based on an honest but incorrect belief. The intent wasn't malicious, but it still creates an informational defect that renders the contract voidable. If the defect is severe enough, it moves past voidable and triggers the absolute void condition, bilateral mistake of fact. This requires that both parties are factually wrong about a core element of the exchange, like the existence or the actual identity of the goods. If both parties agree to trade a specific cargo ship of cotton, but that ship sank yesterday, the foundational logic is gone. The contract dissolves instantly. Consent measures the purity of intent. Corrupted intent makes a contract vulnerable, but completely mismatched intent means there was never an agreement at all. This is the contract validity matrix. You can predict any agreement's survival by systematically testing for structural defects. The definitive void triggers are a lack of consideration, minority status, and bilateral mistakes. These flaws strip the contract of all legal oxygen immediately. The voidable triggers are coercion, undue influence, fraud, and misrepresentation. These infect consent, meaning the contract survives until the victim chooses to strike it down. The Indian Contract Act goes beyond the signatures on the page to audit the legal value exchanged, the sovereign authority of the actors, and the cognitive purity of their agreement.